Well, good morning. So glad to be here with you this morning. I appreciated that speech and appreciated being able to hear from your candidates. It's inspiring and takes us into really what we're talking more about this morning. One of the things that in the last year happened is our vocabularies expanded. We learned new phrases like contact tracing, social distancing, doom scrolling. Anybody got that one? Flatten the curve, PPE, and Zoom, which became a verb for us all, right? I actually, true story, had a friend in January of last year that he was always giving stock tips and I never paid attention to them, but he did say, hey, you need to get in on that Zoom thing, which I didn't even know what Zoom was at the time. So that was one we all missed. But have you heard this question lately? What's the new normal? We heard that all last year. To be honest, I really resist that question because it really assumes that there was a static point in time before the pandemic and now we'll move to a static point in time on this side of it. And in reality, especially with technology, but also in court process, that it's more continuous change. And that aspect of continuous change just happened to be accelerated in the last year. Technology capabilities will always outpace policies and best practices. We understand that. But when those policies and best practices are formed, the next challenge to leaders is then overcoming the aversion to change from the people that participate in the process. That is until the pain of changing is less than the pain of not changing. And in the last year, that's what we felt, and it was pretty remarkable. It was really a seismic shift in the amount of change that participants in the justice process were willing to go through. Now, the pandemic did not change anything about courts' responsibilities, about due process, the roles of the parties that are involved. But what it did do was change the expectations of what's possible, of what's reasonable, and what's acceptable for how this process will play out. It wouldn't be a proper NACM conference if we didn't have a legal pun, so I'll go ahead and get that out of the way now and say the bar has been raised for all of us. By way of introduction, if you're not familiar with Tyler, we're the largest software company dedicated exclusively to the public sector. We're an S&P 500 company with offices from Arizona to Maine, and we support courts all over North America and Australia. And all we do is software for the public sector. We're organized by parts of government that we serve, and I'm responsible for our courts and justice solutions. Now, most of you here have experience with Tyler in one way or another. You may have experience with us through our courts and justice solutions, but if you don't have experience with that, more than likely you have experience with us as a citizen or as a parent of a child, because we provide solutions for more than just courts. We support more than 200,000 public sector employees who rely on our software to do their jobs, with 27,000 installations and 11,000 distinct agencies. And we've been serving courts for 35 years. And over that time, we've grown to serve 55% of the U.S. population with our courts and justice solutions. So naturally, we look at things through a lens of technology. We look at the justice system through this lens. As part of framing our time together, I just want to review some realities of technology change in the last 10 years that's really brought us to this unique point in time. Technology is everywhere. That is no surprise. We all feel it. But But what's interesting to see are some statistics like this. This is from the Pew Research Center. And it shows the growth in cell phone and smartphone ownership among U.S. adults over the last 10 years. So now almost 9 out of 10 adults own a smartphone, and that's compared to less than 30% 10 years ago. That's quite remarkable. And we've seen communication transform over those last 10 years, partially because of that. From what was just an audio experience to a full audio and visual experience in the palm of our hands. There is good that's already come of that. And we have technology as one of the solutions that we have within Tyler is for jails and is for inmates and for their families. And during the pandemic, using video conferencing technology that are installed in jails, VendEngine, which is a solution of Tyler, gave 40 million free minutes to inmates during the pandemic for them to be able to connect with their family. We know during the pandemic, being able for people to travel and connect with their loved ones was something that was taken away. So this was an important and valuable reality of technology that was able to be used. Inmates are now able to join birthday parties, join funerals, conduct job interviews while they're still incarcerated so that as they are ready to be released, then they can be productive and get on with their lives. And we understand that one of the main ways that we can reduce recidivism is by keeping inmates connected with family and friends. We've also seen rapid changes in commerce and in payments. The amount of digital payments now that are being used is exponential compared to what it was 10 years ago. I read an article in the Wall Street Journal yesterday that said now 1 out of every $7 that are spent on retail goods are done online. I think I can recognize that statistic, especially during the pandemic. In courts, Tyler has observed that even just looking at sending a text message to remind someone of a payment has increased payments by 22%. Technology is powerful when we use it the right way. So let's talk about these expectations, and that being the big thing that's changed over the last year. The adaptations that the courts have made have forever changed the expectations of all of the parties involved. The public, we know, is now better able to participate in the justice process since courts are more online. Chief Justice Nathan Hecht of the Texas Supreme Court is quoted here where he said they saw a shift from 80% no-shows to now 80% attendance rates in several case types. Legal professionals continue to see e-filing expand in courts across the country with more options to access cases online and then naturally with virtual hearing capabilities for the ability to move cases ahead and work with the courts. And the judiciary, it really does feel like has changed forever. In a poll that Tyler sent to judges and court executives that we work with, we sent this last fall. And we asked what changes that were part of the initial adaptations that courts made when the pandemic started do you believe will become permanent? 100% said that alternatives to in-court procedures such as video hearings would be permanent. We are in an adolescent phase with these technologies, though. They're not purpose-built for the justice process. And so I know many of you have experienced these growing pains. We all have seen what that can mean. In Texas, the poor attorney had his filter turned on, and if you remember that video, he said, "Judge, I'm not a cat. I'm ready to proceed." I appreciated his attitude. but it is reflective of where we find ourselves in this transition in using these technologies. So there's maturity needed in the solutions, and there's best practices so that there's a consistent and a controlled environment ahead for us. So for the rest of our time, I want to highlight some real advancements that courts are making in this time of continued change. And we'll look at an example of increased access to justice. We'll look at an example of speed to justice, and we'll talk about agility of justice. So in our first example, we'll continue with the focus on remote court proceedings. And for that, I want to invite Riley Miles to the stage with me. Riley is my colleague at Tyler, and Riley's area of responsibility is with our municipal courts. Riley's been working on technology for the justice system for 16 years and is going to share with us some of the experiences that courts have had using a purpose-built platform to manage virtual hearings. So Riley, thanks for joining us.
Yeah, thanks Rusty. And before we dive right in, I have to say this. When you present to these many people, you look at people like Rusty and President Bement and some of the presentations that have been given, it looks so easy. This is nerve-wracking, but I can say this sincerely, and I don't think I've ever said this sincerely before. I am so happy to see all of your faces. After last year, it is so great to be in the room with you and to see you all here. So thank you for being here and thanks for having us.
Yeah, good. Riley, so you've been working with courts to innovate with them on better solutions for virtual hearings. And this started out with traffic case types and infraction case types. So would you share with all of us what you've seen in the last year?
Yeah, absolutely. We've really seen, and I'm going to expand over further than last year, for many years, courts across the country have really valiantly been trying to find the best possible solutions that could improve efficiency, connectivity, convenience. As Rusty mentioned before, as technologies change though, I think we constantly find ourselves chasing that technology around. So if you look at the landscape, we've all found ourselves trying to keep up with things like video conferencing, things like text message notification, just case management solutions, e-filing, document management, the list goes on and on. At Tyler, we've seen clients doing their very best in order to try and make things better for themselves, really create these spider webs of solutions. And I think we can probably all relate to what goes into that. As I've talked about this before in webinars kind of leading up to this, the pandemic hit all of us extremely hard. And there was a lot of difficulty that came from the pandemic, but I think there's also some good. It helped push us as neighborhoods and as societies and as communities. It helped us move forward many years, I think as many as maybe 10 years ahead on adopting online tools and connectivity. So based off of that, I think we can all agree as we look at these spider webs, we can say we can really do better than what we've been doing. And I think now we have the opportunity to try and consolidate those down into, as Rusty described, really purpose-built tools. As a vendor and as your partner, I think we feel like it's our responsibility to do that for you. We want to really push the envelope on integration and connectivity. We did this out of the gate with a solution that we call Virtual Court. But today I want to share with you just some ideas that we've had along the way and what we think should be expected as you look to consolidate these things down. First and foremost, as Rusty mentioned before, and I think all of us can relate to this, the system should be purpose-built for the judicial system. It's tough to piecemeal things together and really have them work the way that they quote-unquote should. I think anywhere that a participant can log in with an internet connection and a webcam, they should be able to, and they should have that convenience at their fingertips. Judges should see pertinent case information in screen, and I think they should be able to interact with participants in the case in a very natural way. Court clerks and staff should really be able to update case information, generate orders, process workflows, collect fines and fees, all just by using the application. Data should be at their fingertips. and you should be able to make decisions off of that data. And of course, it should all be tied in together in that one bundled, consolidated solution.
So I had a chance to catch up with Clerk Deborah DeBerry right before we started sessions this morning, and I hadn't seen Deborah in a year and a half, just like what we see with others, and hearing from her about what the DeKalb County Court is doing with virtual hearings was inspiring, and it goes along to what we're saying here. And she was talking about how she was able to sit in on quite a few of the sessions recently, and seeing defendants. She said she saw one gentleman with a hard hat. She could tell he was sitting in a Bobcat. He was clearly on the job, but he was able to participate in the court proceedings. That's one example. There's other examples about mothers with children that aren't able to secure childcare. These are the things that we know that will increase participation and then it help us down the line. Riley, what are some of the outcomes that courts have seen since that you've seen courts have had in the last year with this?
Yeah, the impacts have been broad-reaching. The impact of the pandemic specifically, I know we've talked about this a lot the last year, but it impacted just the general operation of the courts. As President Bement said, it was an intimidating time to be a part of our community and to want to try and understand what was going to happen. Luckily, we were on the verge of releasing virtual court at this time anyway. So the impact there was significant in that clients didn't have to completely shut down. They were able to transition hearings to online, and it gave defendants a way to safely speak with judges about their cases. But the impacts weren't just limited to what has happened during the pandemic. We have clients, as Rusty mentioned, that really have pushed forward the convenience factor of what virtual hearings can do. We have clients that are near interstates, and we'll see a lot of citations that are written for defendants that are far away, even out of state. Now those defendants have a very convenient way to get online and resolve those cases. We have other clients that have related the fact that there's so many disadvantaged defendants, ones that are just unable, whether physically, financially, or otherwise, able to make it to the court for those important dates. Now they have the ability to log in from anywhere they are and still be able to participate and avoid missing those important dates. One of my favorite examples of what's going on comes from our friends in Del Rio, Texas. Judge Bain and his staff, I think, are doing a fantastic job of reinventing and really reimagining the way that court can be conducted. They are taking court out of the four walls of the courthouse and essentially implanting it in the communities via community centers. So at predetermined dates and times, just a single court clerk will take a laptop and go to a community center. While at that community center with a simple internet connection and the webcam on the laptop, that court clerk is able to facilitate the entire court session. She can invite the judge in, they can be able to interact with the defendants online in that virtual setting. That clerk is essentially able to process that case from open to collecting fines and fees in that, all self-contained in that single session using our online tools. It's inspiring, and I love the innovation that they're doing there. As far as measurable impact goes, because I know that's what you asked, Rusty, well, how can we measure this? Well, in many of our jurisdictions, we've seen failure to appear rates drop as much as 60%. I mean, I don't want to ask you to raise your hands, but I think if we all said, could we have failure to appear rates drop by 60%? I think we would all collectively raise our hands together. The convenience of being able to log in and have access to that hearing and that court date from anywhere is a game changer to, just as Rusty said, to those single parents, working parents, to those participants that otherwise would have to make that tough decision of whether to make that date or to miss it.
Those are impressive statistics, and this audience appreciates what that really means, is by being able to resolve the cases earlier. These are defendants that are avoiding license suspensions, they're avoiding more fees, they're avoiding possible arrests, which just adds to the load of the system, but it really makes life more difficult for the defendants. So just that's the picture of what court professionals I know in this room are interested in bringing to their own courts. So Riley, I know that we started with traffic and infraction case types, so will you just give us a little bit of insight of where we're headed after that?
Yeah, and the reason that we did that was because we wanted to make sure that virtual court could handle the large caseload, the fast processing of those cases, and it does it extremely well. It's really given us a sure foundation upon which to build. Really the vision and where we're going, the future is for virtual court to handle all case types. We recognize the value that it can bring there, but we also know that with additional case types, with additional case parties, there's more complex functionality that's required. So in essence, we're adding that functionality. We're enhancing virtual court to be able to handle multiple case parties, many case parties, so that we can expand into all of those different case types. We're also increasing in the in-court experience by adding breakout sessions or conference rooms to be able to have that in-court processing, kind of a sidebar type of feature. We're also streamlining the document management flow, and we're enhancing the system to be able to accept document signatures virtually as well. Virtual court also allows you to save the video of the session, so it already allows you to save that for the court record, but we're going to continue to enhance it and add transcription services to it as well. And all really in an effort to make that online experience as close to the in-person experience as possible. We're also bringing the general public into it. We'll have a live feed option for the general public to be able to log into and to be able to view and participate in, just as though they were sitting in the courtroom itself. Really, the biggest part of the vision for me is that integration and connectivity. We've really consolidated down the spider web. We've removed some of those webs and consolidated that down to a complete solution. Now we're just going to push it to do more.
Can that be ready next week?
We're going to have to get started. We're going to work through the night. Yeah, we're already on the way.
Well, I mean, we recognize that these things take time to mature, and there's a lot of technologies available, but being able to have a purpose-built solution for the justice system, it's really an extension of case management and brings a lot of the others into the fold is where we're all headed. So, Riley, thanks for joining us,
You bet.
sharing some of the experiences that you've heard that our courts have been doing.
There you go.
The second feature that we can look at is about speed of justice, and we'll take a look at an example of where law enforcement and courts partner together for speed of justice. Reducing injuries and fatalities from intoxicated motorists has long been a focus of not just the justice system, but law enforcement and the public overall. But the justice process begins when law enforcement has this contact with motorists on the street. With 3,000 to 4,000 DWI arrests every day in the United States, we know that's a significant cost, and time is of the essence in the process. To date, 34 states have expedited blood draw warrants for those that refuse a breathalyzer test. And in this race against time, minutes matter to collect this evidence so necessary for prosecution. 0.15% of blood alcohol content dissipates every 60 minutes. That's significant. So when we think about that in terms of a timeline, if there's a typical process where an officer has to go find a judge or a magistrate to sign a warrant and then come back, when you compare that to a fully digitized process, it can save at least an hour. That's just one example of what a digitized warrant process between law enforcement and courts can provide. And so Now we're going to take a look at what the state of North Carolina is doing. The state of North Carolina has a digital warrant process for all of their courts and law enforcement agencies. They did that several years ago. Tyler is partnering with the state of North Carolina on a new cloud-based, mobile-first solution. I recently spoke with the executives, Brad Fowler, Chief Business Officer of the AOC, and Judge Andrew Heath, the Director of the AOC, about this project. So we'll hear from them now.
So prior to having an electronic system, there was no way, even within one community, for a law enforcement officer necessarily to know that somebody had a warrant out for their arrest. So if they're doing a traffic stop or really interacting with a defendant in any situation, they wouldn't necessarily know point in time that there were outstanding processes. So that two things could be negatively impacted. One is it could be a dangerous person and they not know that. The second is they could literally have some contact with them and they could have a warrant out for their arrest and they not know, the law enforcement officer not know to arrest them.
There's a lot of complexity in the state of North Carolina. It's a big state. There are over 600 law enforcement agencies, and we have 100 counties, each with a courthouse and their own staff. And so it was difficult to connect our courts and our law enforcement just because of the size and scale of the solution that we were going to need.
Well, historically, law enforcement would drive to a judicial official, magistrate or judge or clerk, typically in North Carolina. And so that takes a lot of time. That also takes officers off the street while they're doing that. So with our NC Aware and with e-warrants, what we'll be able to do is request and approve many of those processes electronically. And so an example might be, historically here in North Carolina, there's some pretty small law enforcement agencies. And so when you take an officer off the street, you're taking a significant chunk off the street. As you move to, say, the Outer Banks in North Carolina, there are law enforcement agencies that may be a long way, maybe an hour, maybe more, especially, honestly, during the summer, during tourist season, to get to a magistrate's office. The vision really was to move from paper, so both paper in law enforcement offices and paper in courthouses when it comes to warrants, and move toward digital so that officers didn't have to handwrite, eventually transport to courthouses. And so what electronic process allows is that you enter the information, it's available almost instantaneously. And it's also calls out, we have integrations with our Department of Motor Vehicles. So law enforcement can enter a license number, it populates the entire form with that contact information. So it reduces errors, and then it allows instantaneous and real-time information. And that real-time information is two-way. So in our case, when usually a magistrate finds probable cause, for example, that information is stored electronically and is immediately available to law enforcement statewide. And so not just within a county, someone might not be aware of a process. Even more common across the state, someone 200 miles away would have no way of knowing that there's a paper process sitting in law enforcement or a courthouse somewhere 200 miles away. And when you go to a statewide warrant repository the way we have, that information is instantaneously known. So it dramatically increases the efficiency of the system. I think we have to think beyond our individual silos. So both budgetarily and practically, people often think about their agency, whether it's law enforcement or the courts. In this case, this partnership requires more expansive thinking. So it is a benefit directly to law enforcement. Talked a little bit about officer safety and efficiency. More warrants get served. It also gives them real-time information. So that is a value to law enforcement. It's certainly a value to the courts to have that information immediately sent electronically to us. So I would encourage people to work in partnership. This was a long partnership between law enforcement and the courts in our community. And so yes, it did, in our case, end up on our budget side of the house. I think leadership across the judicial and law enforcement, it was important to not just think only about, where does it end up budgetarily, although that's important, but to think of it as a system-wide solution.
I appreciate those gentlemen for participating with us, even though they couldn't be in person because of limited attendance. But it is a big vision that they have in the state of North Carolina, and we're happy to be partnering with them. In our last feature, we'll talk about something a term that may not have been heard as much, but we'll call it the agility of justice. And I want to talk about the hidden asset that we have in court system that's the most valuable asset that we're not able to glean as much from, and that is the data. The data to make decisions with, the data to innovate with, to try things, to track the outcomes. Every court is looking for ways to use this data, but there are inherent challenges in extracting that data. There's two main challenges. The first is the data oftentimes is spread across different systems. We'll call those silos. Even inside of a silo, the data that may be used inconsistently. So in a case management system, for example, case events and statuses between different case types may be used differently. And they may be used differently for good reason. So the challenge is then rationalizing the data so that it can be used and it can be acted upon. And anyone who's worked in courts or has worked with courts, myself included, has spent many, many hours dealing with reporting from courts, whether it be standardized reports, whether it would be reporting to the state. These are challenging and oftentimes legacy systems that we're trying to fulfill. We have reports that policymakers need, reports that justice partners need, reports that funding bodies need, and then the ability for court management to get insight into their own data so that they can find efficiencies. So with that ominous setup, I'm going to invite another colleague up to the stage to address how we can systematically overcome these challenges. Ellen Reed is a product manager focusing on justice system data analysis products. And before coming to Tyler, Ellen worked as a paralegal for pro bono programs, as well as she worked for the Washington State Bar Association. Ellen's an active volunteer and is a member or chair of multiple committees that focus on technology in her home state of Washington. So Ellen, thank you for coming down to San Diego to join us this morning.
Thank you for having me.
Now, Ellen joined Tyler through an acquisition of a company called Socrata. And Socrata was the leading data analytics company platform for government. And Tyler's vision was to take the power of that platform, the expertise of the people, and combine that with Tyler's existing solutions to allow our clients to get the most out of their data. Now, Socrata had a lot of clients, and a sampling you see here that ranged from federal government, state government, and city. But historically, only the largest agencies have been able to successfully deploy a data program to provide these insights. And each of those programs are unique and not transferable to other agencies. So Ellen has been working with courts for multiple years on repeatable yet flexible solutions for courts to use. So Ellen, as you are talking with courts around the country, what are the things that you're hearing from them that they're most looking to solve with data?
Thank you, Rusty. Yeah, it's been really interesting lately, especially during the period where people are coming out of the pandemic. There's a ton of questions that people want to try and solve with data, but as I was thinking about this, there's really three primary issues that have come to light, and the biggest ones that courts are trying to deal with data. So the first one that's up here is really kind of the key question. How can I quickly reduce my case backlog and predict what case filings might surge? Courts are, of course, dealing with, criminal especially, backlogs that are just totally unprecedented and huge. And so they're looking at how they can move through those quickly while also realizing that there's other case types where people have really held back their filings, or there's case types like eviction where there's a reason that no cases have been filed or very few cases have been filed, and we're going to see some changes there, as well as administrative orders lifting. So there's this kind of push and pull happening where there's been a lot of incoming cases that are unable to be processed, and there's also been this vision of this coming tsunami of other case types. So I'm actually going to return to this in a minute and talk to you about it a little bit more. Another really critical question has been what changes to case processing have really shortened that critical path from filing to disposition. I've been working with courts, with the legal profession for about 12 years now, and I have to say, I would never have predicted what I saw during the pandemic, how quickly the courts pivoted and changed, and all the innovation and expertise that was applied to seeing how can we really shorten that critical path from filing to disposition and make sure that we move litigants through for the cases that are still active. So really some amazing innovations there, but courts are trying to evaluate, are remote hearings appropriate for all case types? Where should we be doing that? Where should we be not? And so collecting data that can support where those innovations are going to continue and be applied has been a really critical piece of what courts are trying to do. And then this is also a really big one. We talked about this a little bit earlier this morning. But there's been a huge demand for accountability, for criminal justice reform, for justice reform across the board. And so a lot of courts are struggling with how can we communicate both what is going on with our current practices. A lot of courts have been talking about how can we show whether our sentencing procedures are equitable, for example. So being able to show that through the data, but also being able to communicate progress that's being made. There's a lot of new types of problem-solving courts that are coming to the fore. How do we communicate that out to the public so that they can see what we're working on and where we're really trying to go? So I'm going to go back to that original question that we talked about with examining the case backlog and just talk a little bit about what I've seen courts trying to do with their data. And there's really kind of three primary strategies that I've seen. The biggest one that I think almost everyone is doing is trying to triage. So getting into their oldest cases. This diagram that you see up here represents cases that are in different stages of active pending. So cases that have been around for 30 days, for 60 days, for 180 days, et cetera. So a ton of courts are diving into those oldest cases, and they're just trying to look at it on an individual level. How do we move this case through? What kind of case event has this gotten stuck on? Has there been a ton of continuances in this case? Is one judge overloaded, so some of these cases aren't moving? So that's been a big piece of the puzzle, just trying to triage individual cases. But then, of course, a lot of courts are applying that on a wider level. So they're looking at their different case events, their case statuses, and they're trying to understand how is that really going across all of our case events so that we can, again, apply some of those innovations that we tried during the pandemic to try and clear this backlog and potentially hire more staff that can help us get through it as well. So really, again, looking at those judge caseloads. But the other piece of this puzzle has really been trying to predict the coming surge. And what I've seen courts there has been really interesting. There's a lot of comparative analyses of caseloads from before the pandemic, looking at that and then figuring out, do we think that cases were withheld? Can we add those cases that we think were withheld to the cases we would normally see and try and predict how many cases we think we're going to see. But beyond that, of course, there's a need to pull in data from other sources. So some rural counties have seen huge population changes. There's, of course, data related to the evictions that we see coming that may be different in different areas, but there's usually some outside research that you can pull in. So one thing we've really been working on is trying to enable projection models in our Insights applications, which I'll talk about in a minute, and really allow you to play with those different scenarios. So you can look at those different projection models, look at that outside data, add in those multiple factors, and be able to see, what might be coming our way. And I've been really impressed by a lot of the work I've seen the courts doing there.
Well, Ellen, I know Ellen could stand up here and speak literally for hours. She loves this,
Yeah.
And we love having her on the team because of that love. But I want to make sure that we cover a very specific project that you're working on with one of the clients, and it's a state administrative office of courts. And this state has a big vision for transforming the reporting of both courts and probation and pretrial information across the state. So can you tell us about some of the goals of that project?
Yeah, absolutely. So, the challenges you talked about initially, Rusty, in terms of getting data on a consistent basis and then standardizing it in some way. This court was really struggling with those challenges, especially the data collection piece. So what we're developing with them is a way to actually set up constant feeds of data from their court case management, e-filing system, probation pretrial system, so that the data is always up to date, it's always flowing in, standardize that data across the entire data platform, and then be able to provide not just statewide access to that data, but also local access to that data with our Insights applications, which I'll talk about. So the first one is eFile Insights. I want to give a little shout out to our design partner, Texas, that was originally coupled with us in helping to develop this application and gave us a ton of great suggestions, really shaped it. So eFile Insights focuses on the performance of the e-filing system. So incoming cases, incoming fees. It also gives clerk supervisors insight into the duration that it's taking clerks to process filings, into the reasons for returns, rejections, and into the filing patterns of self-represented litigants. And so everyone who has access to this application and to all of these applications can create their own dashboards, just include the metrics that are relevant to them, and they're just going to see the data that relates to their court or their jurisdiction. Probation and pretrial insights, as you can see, very similar in structure, and that we see as a real advantage because once someone learns how to use one of these applications, they can use all of these applications. And this is going to create a new reporting structure for the state and really allow them to see data that they've never seen before. And a lot of the goal of that is partially just to allow that data sharing within the system, but also partially to be able to talk to policymakers, to other stakeholders in the justice system, so that they can really surface what's happening and be able to see the effect of any new reforms that come. And then finally, I think the most important one for this state is Court Insights. And what they're really trying to do with Court Insights is bring in that Court CMS data, standardize it, and be able to really eliminate their traditional reporting structure. So it's going to remove thousands of hours of manual reporting and a lot of reminder emails. And so it's really, really key for them just to be able to have that constant flow of data and really just take out the sort of piece where people are having a hard time getting it together, having a hard time aggregating it. And it allows this data to also be used on a local level so that it's held, not necessarily at a statewide level, it's not growing stale. So you can actually get in there as a local administrator, you can see what's happening on a day-to-day basis, and you can figure out what the problems are, figure out data-driven solutions, and really be empowered by your data.
It's exciting.
Yeah.
It's exciting. Thank you, Ellen, for joining us.
Thank you.
Thank you very much.
Thanks, guys.
So those were three examples that I think that when we look at them individually, we can see how the realities of technology, the evolving expectations of users have really brought us to a point to where each of those three, you can see over the next 10 years how those become more standardized in our industry. So the question I leave you with is, when you think about these evolving expectations, what are you doing to take advantage of this window of opportunity that we have? And that's what these conferences are good for. It's the ability to stop, take a step back, evaluate your strategies, be inspired from your peers. So with that, I'll say thank you for joining us today. The Tyler team would love to connect with friends and meet new ones. So I hope you'll come by and see us at the Expo Hall tomorrow. Thank you very much.